Hello everyone, welcome to part 2 of All India Bar Examination Past 10-Year Solution series, and today we are solving the 2013 paper of the AIBE. Let us quickly start. Dash is the process whereby interested parties resolve disputes, agree upon courses of action, bargain for individual or collective advantage, and or attempt to craft outcomes which serve their mutual interest. The answer is negotiation D. The fundamental aim of legal ethics is to maintain the honor and dignity of law of profession, to secure a spirit of friendly cooperation between the bench and the bar in promotion of highest standards of justice, to establish honorable and fair dealings of the counsel with his client, opponent, and witnesses, to establish a spirit of brotherhood in the bar itself, and to secure that lawyers discharge their responsibilities to the community generally. Whose statement is this? The answer is Chief Justice Marshall. It is impossible to remember everybody's statements. Therefore, stick to the past year papers. जहाँ पे भी ऐसे बड़े बड़े statements दिए गए हैं, try to remember those. So this is Chief Justice Marshall, honor and dignity. ठीक है. The Supreme Court has held that an advocate cannot claim a lien over a litigation file entrusted to him for his fees. No professional can be given the right to withhold the returnable records relating to the work done by him with his client's matter on the strength of any claim or unpaid remuneration. The alternative is professional concerned can resort to other legal remedies for such unpaid remuneration. Refer to the specific case. इसका आंसर है R.D. सक्सेना वर्सेस बलराम प्रसाद शर्मा. R.D. सक्सेना वर्सेस बलराम प्रसाद शर्मा में रेन्यूमरेशन और लियन ओवर लिटिगेशन के बारे में बात की गई थी. Now let us quickly solve the other questions because these first three were very lengthy. Others are quite to the point. Duty of an advocate towards his client is detailed out in which rules of the Bar Council of India, and the answer is 11 to 33. Which section under Advocates Act 1961 deals with disqualification as to enrollment? Section 24A. Existence of two suits by parties litigating under same title, one previously instituted is pending at present and the other filed later, wherein a matter is assured in the subsequently filed suit is directly and substantially in issue in other, and the relief claimed in the subsequent suit can effectively pass by the court of the previous instance. Which section of CPC decides the fate of the subsequently filed suit and its proceedings? This is section 9. Where there are mutual debts between the plaintiff and defendant, one debt may be settled against another. This can be statutory defense to a plaintiff's action, and this is called as set off. An attachment before judgment order takes away power to alienate the property. The three pillars on which foundation of every order of injunction rests: prima facie case, irreparable injury, and balance of convenience. Dash is to enable subordinate courts to obtain in non-appealable cases the opinion of the High Court in the absence of a question of law, and thereby avoid the commission of an error which could not be remedied later on. Reference. Who decides as to which of the several modes he/she will execute the decree? Decree holder. Where a party to a suit requires information as to facts from opposite party, he may administer to his adversary a series of questions. It is called interrogatories. Dash is a suit filed by or against one or more persons on behalf of themselves and others having the same interest in the suit. This is representative suit. A person appointed by the court to protect, preserve, and manage the property during the pendency of the litigation is known as the receiver. He's receiving the property. That is how I remember this. The provision under CPC that relates to suit by indignant person deals under section Order 33. So Order 33 deals with suit by indigent persons. Section 5 of the Limitation Act 1963 enables the court to condone delay in filing dash on sufficient satisfaction of sufficient cause. Answer is appeal or application. Appeal or application. A. Then limitation period prescribed in filing a suit by a mortgagor to recover possession of immovable property mortgaged. This is 30 years. Limitation period prescribed in filing a suit by a mortgagor to recover possession of immovable property mortgage is 30 years. Then, which are the provisions under Indian Evidence Act 1872 that deals with relevancy of opinions of experts? Option is C, 45 and 46. Then, the contents of documents may be proved either by primary evidence or secondary evidence. Oral accounts of the contents of a document given by some person who has himself seen it is secondary evidence. The DNA test cannot rebut the conclusive presumption envisaged under Section 12 of the Indian Evidence Act. The parties can avoid the rigor of such conclusive presumption only by proving non access, which is a negative proof. And this was held in the case of Sheikh Fakhruddin versus Sheikh Mohammed Hassan in the year 2006. The statements of dead persons are relevant under which provision? This is Section 32, Clause 4, and option is C. 23. Witnesses are the eyes and ears of justice. Whose statement is this? ये है Bentham again. An accomplice is unworthy of credit unless he is corroborated in material particulars is a 24 का आंसर है A, presumption of fact. An accomplice is unworthy of credit unless he is corroborated in material particulars is a presumption of fact. Patent ambiguity in interpreting documents renders it incurable. Promoting enmity between different groups on ground of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony is an offense under which provision of the Indian Penal Code? The answer is Section 153A. The gist of this offense is meeting of minds. 120A, Section 120A of the Indian Penal Code. See, a lot of times they have not mentioned which act they are talking about. So even though ये direct question है, you can easily see section 120, 133, 221, section 340, even if you don't know the right answer. But ये तभी होगा जब आपको पता होगा कि ये कौन से act के बारे में बात कर रहा है. Now, if you are to see transfer of property act on this question, आपको मिलेगा ही नहीं. So there are a lot of things which you are to consider while you are preparing for this exam, and basic ये है कि आप table of contents पढ़ के जाओ, so at least you know where to find the answer. I'm not saying that you should memorize each and every section and you should know everything, but at least इतना पता होना चाहिए कि आपको ये आंसर ढूंढना कहाँ पर है, right? Now let us quickly move on to section question 28. A places men with firearms at the outlets of a building and tells B that they will fire at B if B attempts to leave the building. What is the offense committed by A as against B? The answer is wrongful confinement. Adulteration of food or drink intended for sale is a punishable offense under Section 272. Voluntarily causing grievous hurt to deter public servant from his duty is cognizable and non-bailable offense. So don't do that. Again, A obtains property from Z by saying, your child is in the hands of my gang and will be put to death unless you send us 10,000. This offense is बहुत simple है, ये extortion का case है. Typical crime patrol case. Let's move ahead. Which provision under Criminal Procedure Code 1973 deals with the procedure to be adopted by the magistrate to record confessions and statements? The answer over here is A, Section 164. Any police officer may, without an order from a magistrate and without a warrant, arrest any person who obstructs a police officer while in the execution of his duty or who has escaped or attempts to escape from lawful custody under Section 41, Clause E. The plea of bargaining is applicable only in respect of those offences for which punishment of imprisonment is up to a period of 7 years. Which provision under the code provides the indication as to the rule against double jeopardy? The answer is section 300. Moving on, sorry, the answer is 300. If an accused is charged of a major offense but is not found guilty thereafter, he can be convicted of minor offense if the facts established indicate that such minor offense has been committed. ये कौन से केस में किए हेल किया गया था? आंसर है स्टेट ऑफ हिमाचल प्रदेश वर्सेस तारा दत्ता. Tara Datta minor offense, remember this. Provisions of Section 195 of the Code on mandatory and non-compliance of it would okay, there was some connection error. Let us continue. Provisions of Section 195 of the Code are mandatory and non-compliance of it would initiate the prosecution and all other consequential orders. This was held in the case of C. Munappan versus State of Tamil Nadu. Order granting anticipatory bail becomes operative on arrest. A contract made by a trustee in excess of his powers or in breach of trust cannot be specifically enforced as per Section 11, Clause 2. Under Section 41 of the Specific Relief Act, an injunction cannot be granted. All of the above. Read section 41 and you will obviously carry this bare act. So this is very easy. Specific relief can be granted only for the purpose of enforcing individual civil rights and not for mere purposes of enforcing a penal law. Which provision brings this prohibition? And the answer is A. 4, section 4. It was held by the Supreme Court of India that preamble was not a part of the constitution in the case of dash and this has been overruled in the case of. तो यहाँ पे बहुत important है कि you read the order in which they have asked you the question and according to that the answer is A. तो re बेरुबारी यूनियन में it was held that preamble is not a part of the constitution और इसको overrule किया गया था केशव नंदा भारती के केस में in the year 1973. Then by the Constitution 97th Amendment Act 2011, the following word has been inserted under Article 19(1) Clause C. Cooperative societies को ऐड किया गया था. Doctrine of legitimate expectation was discussed in the following case. Food Corporation of India versus MS Kamdenu Cattle Feeds Industry. Remember cattle feeding and legitimate expectation that you should feed a cattle and that is the legitimate expectation of a cattle. That is how I remember this case. The Supreme Court in Selvi and others versus State of Karnataka held that compulsory brain mapping and polygraph test and narco analysis were in violation of the following articles and the answer is 20 and 21. Passive euthanasia is permitted in certain cases. This was held in the case of Aruna Ramchandra Shanbag versus Union of India, popularly known as Aruna Shanbag versus Union of India. Delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or disposed of according to the directions of the person delivering them. What type of contract is this called? Bailment. The essence of a contract of agency is the agent's representative capacity coupled with power to affect the legal relations of the principal with third persons. A contract is an agreement between two or more persons which is intended to enforceable at law and is contracted by the acceptance by one party of an offer made to him by the other party to do or abstain from doing some act. Whose statement is this? Halsbury. ठीक है. Again, this is a very lengthy question. A's nephew was absconded from his home. He sent his servant to trace his missing nephew. When the servant had left, A announced that anybody who discovered the missing boy would be awarded a reward of 500. The servant discovered that the missing boy without knowing the reward. When the servant came to know about the reward, he brought an action against A to recover the same, but his action failed. It was held that the servant was not entitled to the reward because he did not know about the offer when he discovered the missing boy. This is very, very famous case, and this is Lalman Shukla versus Gauri Dutt. Let's move on to 51. A debtor owes several distinct debts to the same creditor and he makes a payment which is insufficient to satisfy all the debts. In such a case, a question arises as to which particular debt the payment is to be appropriated. Which sections of the contract provide an answer to this question? A. 59 to 61. What property cannot be transferred under Section 6 of the Transfer of Property Act? All of the above. Easement, interest in property, right to future maintenance, ये सब नहीं transfer कर सकते हैं हम. 53 is A transfers property of which he is the owner to be in trust for A and his intended wife successively for their lives and after the death of the survivor for the eldest son of the intended marriage for life and after his death for a second son. Can the interest so created for the benefit of eldest son take effect? The answer is no. The commencement of arbitral proceedings is not dependent on interim relief being allowed or denied under Section 9 of the Arbitration and Conciliation Act. Supreme Court held this in which of the cases? Firm Ashok Traders and others versus Gurumukh Das, Saluja and others. Arbitral proceedings, interim relief, they are not dependent on interim relief. Section 9 and Firm Ashok Traders. Remember the keywords. Which provision of Hindu Marriage Act 1955 deals with conciliation? B. 23 Clause 2. Which section of Civil Procedure Code deals with settlement of disputes outside court? C. 89. Equal pay for equal work can be enforced under Article 14 and 16. The executive power of every state shall be so exercised as to ensure compliance with the laws made by the Parliament and any existing laws mentioned under Section 256. Justice Ramanandan Committee relates to creamy layer. ओबीसी का क्रीमी लेयर की बात हो रही है. Original jurisdiction of the Supreme Court is dealt under Article 131 of the Constitution of India. Laws declared by the Supreme Court shall be binding on all courts. This is mentioned under Article 141. According to the theory of social utilitarianism as propounded by Haring, the answer over here is D. Law is a means to social ends. Obstructing public servant in discharge of his public service is a bailable offense. 63 is B. 64. Compensation to victims of crime under criminal law relates to Section 357. What persons may be charged jointly and tried together under Section 223 of CRPC? All of the above. Just read Section 223 or any such section or provision of CRPC when they ask the question, and it will be very easy to attempt this question. Contravention of Contract Labor Act would not create employment relation between the contract labor and the principal establishment. It was so held in the case of SAIL versus National Union Waterfront Workers. The principal regulator envisaged under Trade Unions Act. This is Registrar of Trade Unions. A teacher is not a workman falling under the category of workman under industrial disputes. ये कौन से केस में बोला गया था? This is Miss A. Sundar Bal versus Government of Goa, Daman and Diu and others. I remember this because they are talking about a teacher and Miss Sundaram Bal sounds like a teacher. Then the type of disablement envisaged under the Employment Compensation Act that reduces the capacity to work in any employment similar to that the worker was performing at the time of the accident is referred as permanent partial disablement. The contribution payable under ESI Act in respect of an employee shall comprise of contribution payable by employer and employee, which provision under the Industrial Dispute Act 1947 guarantees the right of workmen laid off to claim for compensation. C. Section 25 C. Natural law is the idea that there are rational objective limits to the power of legislative rulers. H.L.A. Hart's name is associated with the book The Concept of Law. H.L.A. Hart, Concept of Law. Section 9 of the Hindu Marriage Act deals with restitution of conjugal rights. Daughter is equated with the son with reference to joint family property under this was the amendment of 2005. Option D. Mubarak under Muslim law refers to dissolution of marriage with mutual consent. The discriminatory aspects of Section 10 of Indian Divorce Act was removed by substituting new section by which amending Act Indian Divorce Amendment Act of 2001. Trading activities of a company were stopped temporarily in view of trade depression with an intention to continue the same when the conditions improve. A petition was preferred into tribunal for winding up the company. The petition is liable to be dismissed. 79. Amalgamation of companies in national interest is dealt under Section 396. Section 171 of the Companies Act, a general meeting of a company may be called by giving a notice in writing for not less than 21 days. A private limited company limits the number of members to the correct answer over here is B, 50. Contributory negligence means the failure by a person to use reasonable care for the safety of either himself or his property. 83. Where an enterprise is engaged in a hazardous or inherently dangerous activity and harms result to anyone on account of an accident in the operation of such hazardous or inherently dangerous activity, resulting, for example, in escape of toxic gas, and enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vis-a-vis tortious principle of strict liability. This was held in the landmark case of Shriram Food and Fertilizers. So option B. Then a tort is a civil wrong for which the remedy is an action for unliquidated damages and which is not exclusively the breach of contract or breach of trust or breach of other merely equitable obligation. ये statement है Salmon का. Under Section 20 of MV Motor Vehicles Act, if a person is convicted of an offence punishable under Section 189 of the Act, the court ordinarily shall order disqualification under the Act. Consumer Protection Act was brought into operation in the year 1986. Under Consumer Protection Act, the jurisdiction of the district forum should not exceed 87 का answer है D, 20 lakhs. You have to also see the updated acts because the past year के papers है which are talking about the Consumer Protection Act which was not amended as recently as in the year 18 and 19. So refer to your updated acts. I am only referring to the answer key which was given by the Bar Council with respect to these papers. The second principle of rule of law of AV Dicey refers to equality before law. If a quasi-judicial authority violates the principle of natural justice, the appropriate writ would be certiorari. A seven-member bench of Supreme Court unanimously struck down clauses 2D of Article 323A and clause 3D of 322B of Constitution relating to tribunals which excluded the jurisdiction of High Court and Supreme Court. The court held that the power of judicial review over legislative action is vested in High Court under 226 and SC under 32. This is an integral part of the basic structure. Name the case. ये एल चंद्रा कुमार वर्सेस यूनियन ऑफ इंडिया है. L. Chandra Kumar versus Union of India. Accepting any satisfaction that the performance originally agreed is known as accord and satisfaction, where two parties have made a contract which one of them has broken, the damage with the other party ought to receive in respect of such breach of contract should be either made fairly and responsibly, considering the arising naturally according to the usual course of things from such breach or contract itself, or such as may reasonably be supposed to be been in contemplation of the parties at the time they made the contract as the probable result of the breach of it, in which case the principle was laid down. This was in the case of Hadley versus Baxendale. When a misrepresentation has been made, which are the alternative courses open to the aggrieved? All of the above. Avoid कर सकते हैं, rescind कर सकते हैं, affirm कर सकते हैं, it can rely on the court and use it as a defense. So the answer is all of the above. A solicitor sold certain property to one of his clients. The client subsequently alleged that the property was considerably overvalued and his consent was caused by ये होगा undue influence because relationship between the parties are of a lawyer and a client. So, undue influence. The law of contract is intended to ensure that what man has been led to expect shall come to pass, that what has been promised shall be performed. Whose statement is this? ये Anson का statement है. The law of contract is intended to ensure that what a man has been led to expect shall come to pass, and what has been promised shall be performed. This is a very powerful statement, and there is no way of attempting this question other than memorizing this. So, this is by Anson. Intention not to create a legal obligation was clear from the conduct of the parties. Which among the popular cases deals with the topic? And this is Balfour versus Balfour. Legal obligation nahi tha. According to the Indian law, in a lawful contract, consideration may move from promisee or any other person. Then 98, Raghav owes Murli 10,000. This debt is time barred by Limitation Act. Even then, Murli promises in writing to pay Raghav 4,500 on account of debt and signs the agreement. This contract is enforceable. Then an agency can be terminated. It can be terminated by the agreement of the parties, by renunciation by the agent, and completion of business also. Therefore, the answer is all of the above. Which type of laws are not covered by the contract of indemnity? The option is A. Laws arising from accidents like fire or perils of the sea. Therefore, the right answer is option A. In the next segment, we will be starting with the 2014 paper, and we will be completing all the papers up to the year 2022. Thank you. Bye.